All right, we have a request for guardianship and conservatorship. So we have it's two cases, 24-1-5333 is our conservatorship case, and guardianship case is the one that's already been announced. May I have the names of our participants, please, beginning in the courtroom.
Michael McFarland, attorney, guardian-ad-litem.
And let's go to Mr. McAllister.
Attorney Craig McAllister here on behalf of the petitioner, Miss Paula Dotson.
All right, and if you could either introduce or ask your client to introduce herself, please.
Absolutely. If you could, Miss Dotson, could you please say your full name for the record?
Paula Dotson.
Thank you very much.
Okay, Mr. Michael Dotson, would you want to introduce yourself?
I'm Mike Dotson.
Welcome. All right, Mr. McFarland, do you want to start with your recommendation?
Yes, Your Honor. Just to summarize my report, which I've submitted, Mike suffered a on-the-job severe electrical shock. He's so lucky to be alive. He is recovering, but he's still in the process of recovering. He recognizes that he has a ways to go, and he is somewhat limited by his ability to make decisions at this point in time. I spoke to his wife, Paula. There's nothing objectionable in her history. There are assets, such as house accounts, insurance, things like that will need to be dealt with. So there are assets, hence the conservatorship. When advised of his rights, he believes he does not need an attorney. He was able to hold a good discussion. I have talked to him on a good day, Your Honor, FaceTime with him. So nobody's objecting, and my recommendation is that this be granted.
Thank you. All right, Mr. McAllister, any further presentation?
Yes, really quick, Your Honor. After talking to my client, we had gone forward. Obviously, with the guardianship, she's in the best shape. And Attorney McFarland, thank you again for all your work on this. I believe all parties here believe that Ms. Dotson is in the best position in the guardianship. Ms. Dotson, though, for the conservatorship has nominated Darren Finling here at our office. The only thing I would ask is that we limit the scope of the conservatorship for Darren to just the cause of action at hand that's being pursued. I think we can all agree Ms. Dotson and Mr. Dotson have been married. She's more than able to take care of everything else, every other issue that Mr. McFarland brought up on the record. So based on my talks with my client, she would like that Darren Finling here at my office, the conservatorship, he be placed in charge of only include the scope of the cause of action.
So I have a request to appoint Paula Dotson as the conservator. So I'm not sure. Are you asking me to appoint your office rather than Ms. Dotson?
On here for the petition to appoint conservator, I had originally read here she was nominating Darren Finling here at my office to be the conservator for the cause of action.
I do see that.
Okay. Ms. Dotson, I would frankly prefer that you had the authority in order to decide whether or not the consent, if something shakes out on that settlement, I would think that you would want to make the decision on behalf of your husband rather than just leaving it to the attorney who also has an interest in there. So there's a couple issues there. Number one, we have a conflict of interest in allowing the attorney that's pursuing a cause of action to also be the person who decides what the settlement might be or whether to try the case. And secondarily, I would think that you would want to keep that authority within your family in order to make those decisions as far as what's best for you and Mr. Dotson. So I'd like to hear your thoughts on that. Deputy Ames, would you swear her in, please?
Please raise your right hand, Ms. Dotson. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, Ms. Dotson. Your thoughts, please.
I'm sorry, Your Honor, really quick. Before Ms. Dotson does give her testimony, I just wanted to make it clear on the record that our office is not the office handling the cause of action, the personal injury. That's a separate one. We've just been retained to help with the probate side of things. But again, I completely understand. I did just want to clarify that for the record and let Ms. Dotson give her full and undivided testimony here.
Thank you, Mr. McAllister. I do appreciate that information. Back to Ms. Dotson.
So I'm sorry, Judge, I'm just kind of confused. So you're saying that you prefer me to have the total authority to make all decisions, even with the mass settlement that might be coming?
Yes.
Okay,
You can always ask them what they think. It's not like you can't have them advising you. That's the purpose of an attorney, right? But for them to make that decision for you seems pretty invasive for you and your family. I would think you would want to be able to make the decision as to what you accepted as part of any kind of lawsuit.
yes, I agree.
Is that okay with you, Mr.
I
McManus?
I thought the attorney was there to protect the funds that would be coming in.
So again, essentially, Ms. Dotson, kind of what we talked about on the phone yesterday, whether you are the conservator or Darren here at our office, we're helping either way. We're going to make sure the funds get put into, from the cause of action, are put into an account, obviously for that betterment and well-being of Mr. Dotson. Really, it does not matter. It's half a dozen, 1/6 of the other with how we put it in here. If you're more than willing to serve as the conservator here, we fully back you and support that as well.
Okay, I would rather be the conservator on this and have you guys back me.
I would rather have you do that too.
That
What do you-
supports the discussion that I had with her, Your Honor. That was my presumption after speaking with her.
Very good.
Abs-
Mike,
Absolutely.
do you have anything you'd like to say about this?
No, I don't.
Okay. Are you comfortable with Paula making decisions for you on your finances and medical decisions and some of those things?
Yes.
Thank you. All right, anyone else you'd like us to hear from, Mr. McFarland?
Not necessary, Your Honor.
Mr. McAllister, same question?
I'm sorry, really quick. As far as the conservatorship goes, are we still limiting the conservatorship just to the scope of the any of the lawsuit, the proceeds that come in from the lawsuit? I know Miss Dodson and Mr. Dodson have been married. They already have joint bank accounts. All other home assets, do those need to be included in the conservatorship, or with this, can we just solely limit it to essentially the lawsuit at hand?
Well, Ms. Dotson, I think that's a question for you. Do you think you will need the authority to consent on some of those things? If bills need to be paid or decisions need to be made as far as finances go for your husband, do you think that you need the legal authority to do that?
No, I think I can handle those decisions.
But we still want them though, right? Because, right, there's still gonna be like a part, like, they're gonna help us like do the finance. Like, I'm confused.
So are you talking about the attorneys, Mr. Dotson?
Yes, as far as the conservatorship.
Yes, they'll be there to advise you, but you and Paula will be able to make the decisions for yourselves, but they'll be there to help you.
Okay, perfect.
All right, well, I have no problem limiting your authority there, Ms. Dotson, but it does sound like there are some assets and finances, you know, so if you end up needing that authority to be expanded, you could come back later and ask to modify that to encompass more than just, you know, the authority to consent to what's happening with the lawsuit.
Okay, so now I'm confused a little bit because I thought we just said that I would have more authority to make those decisions.
Yes, you're right. It does sound confusing. So a conservator is somebody that makes the legal decisions. So you would make the decision as far as if you wanted to consent to any settlement on the lawsuit, right? But it would also, as a full conservator, give you the authority to like if Mike has stocks, bonds, or something that's in his own name that need to be moved around, you would have the authority as a conservator to do that for him. But we can also limit it. So what Mr. McAllister is suggesting is that as a conservator, you only need the authority to make the decisions on the lawsuit. I'm asking you, do you need that authority, but also any other authority for different financial things that Mike may need you to do for him in the future.
Yes, I would need that authority.
Thank you. That helps me.
And that also mimics the discussion that I had with her.
No,
Thank you.
again, yes, absolutely.
Okay, all right. So that means that what I would be granting you here today, Ms. Dotson, is the full authority for Mike to make all medical decisions and all financial decisions, all legal decisions, everything that you would need really in order to make sure that he gets all the services that he needs, the medical care he might need, and the authority to do anything financially and consent to like the lawsuit proceeds and all of those things. You'd have everything you need in order to make all the decisions, but all the responsibilities too, right?
Yes.
Okay. All right. So anything else then before I make the final findings?
Not here, Your Honor.
No,
All right.
again, thank you again very much, Attorney McFarland, for your work on this. Mike, good to see you. Glad to see you up and moving. And Ms. Dotson, again, thank you for all your help and cooperation on this.
Thank you, guys.
All right. Well, the court
Thank
finds
you.
all interested parties were given notice for purposes of today's hearing. I have had, of course, the support and investigation of the guardian ad litem to say that he supports a full guardian and a full conservator. I've also had the benefit of reviewing a report of physician or mental health professional that indicates that a doctor of family medicine was able to work with Michael on July 10th, 2024, and diagnose traumatic brain injury, cognitive deficits, PTSD, and a major depressive disorder, which unfortunately interfere with his ability to make sound judgments and decisions in everyday life, as the doctor puts it. There are a number of medications intended to alleviate the symptoms associated with these diagnoses, but nevertheless, as of August 7th, 2024, which is the date of the report itself and the signature of that report, the doctor indicates also support for Michael is necessary because he's not able to make informed decisions in the areas of determining where to live, consenting to supportive services, handling personal financial affairs, and authorizing or refusing medical treatment. That, of course, was confirmed also by my own observations and the testimony of our participants today, including Mike. He has also expressed support that Ms. Paula Dotson should be the person to make those decisions for him until and unless he's able to make those for himself in the future. So all of that does present clear and convincing evidence that the appointment of a full guardian is necessary and that those diagnoses do qualify Michael as an incapacitated person as the law defines it. The petition for appointment of guardian is granted. Paula Dotson is appointed full guardian. I've also had a testimony and support in the file to indicate that there are assets and financial things that Michael has and needs help with as well, necessitating a conservator. So Ms. Paula Dotson confirmed with us online here today that she is willing and able to help with those decisions as well, and that those assets, including that potential lawsuit, are out there, and Michael will need someone to advocate for him on those points. So for those same reasons that the same clear and convincing evidence that caused the court to grant guardianship also forms a basis for the court to grant a full conservator and also to appoint Ms. Paula Dotson in that capacity. So that's what our court orders say and the letters of authority. And unless there's any questions, that's all for today.